Welcome everyone. Thank you for taking the time to join us today. My name is Emily Plosker. I'm a Managing Associate here at BDBF, and I'm being joined today by my colleague, Rebecca Rubin, who's an associate in the team. Today, we're looking at the important topic of sexual harassment in the workplace and what you as employers need to know. As I'm sure you're all aware, the Me Too movement has had a huge cultural impact on the way sexual harassment is perceived in society, and it has certainly shone a light on harassment in the workplace. Harvey Weinstein was just the tipping point, and thereafter there followed a succession of high-profile cases. Businesses are now taking sexual harassment far more seriously. I think IKEA recently made an agreement with the EHRC to improve its own sexual harassment policies. In terms of our own work, we've seen a significant increase in the number of sexual harassment complaints. Employees are definitely feeling more empowered to speak up about their colleagues' behaviour. And I think prior to the Me Too movement, the victim was often the one exited from the business, but now there's been a shift, and more often you see the alleged perpetrator is the one being exited. And it's for all of these reasons that we think it's an important area to discuss, and why we want to share our knowledge and experience of dealing with sexual harassment cases in the workplace with you today. So what are we going to cover? We are going to cover 4 main topics. And we're going to speak for around 45 minutes, and at the end there will be some time for some questions and answers. Just before we start, a few housekeeping points. I guess just to flag that this is a sensitive subject and there may be language which is triggering. We've tried to ensure that we've remained, mindful and sensitive to that in this talk. As you can tell, we're presenting in a webinar format today, so any questions you have, pop those into the Q&A box at the bottom. You can do so anonymously. And finally, the session is being recorded, but the Q&A section won't be. After the session, we will circulate the recording and also a copy of the slides. So without further ado, I'm going to hand over to Rebecca.
Thank you, Emily. Okay, so we wanted to start by setting out some of the basic principles of sexual harassment so that you have a clear framework for this area. So what is sexual harassment? Well, sexual harassment in the workplace takes place where a person engages in conduct which, under the relevant legislation, is described as being conduct of a sexual nature, and which is also unwanted and has the purpose or the effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. The really key point to remember is that the harassment must be of a sexual nature, as that's what makes it distinct from other forms of harassment, say in relation to someone's age, which is, of course, also unlawful. Now, I wanted to give you a few examples of what could constitute sexual harassment, and I've set these out for you on the slide. And as you can see, they include a wide range of things like sexual comments or jokes, suggestive looks, staring, leering, propositions and sexual advances, unwelcome touching, hugging and kissing, and even intrusive questions about a person's sex life, or even discussing your own sex life. So it is also sexual harassment if a person is treated less favourably because they've either rejected or they've submitted to sexual harassment. And an example of this might be if one of your employees tells a supervisor that she doesn't want to kiss him, and after that, the supervisor starts making things more difficult for that employee, such as criticising her more than others, then this could constitute sexual harassment. Now, hopefully that's given you a clearer idea of what sexual harassment is. And I now want to take you through some important general points that I think you need to bear in mind. The first is that sexual harassment can happen to anyone. So a man or a woman, young, old, straight, gay, bisexual, junior, senior, anyone. Secondly, it can be perpetrated by anyone. So it can be done by a peer, but it could also be done by someone more junior to the employee. There is evidence, however, to show that generally there's a greater risk of harassment coming from someone who has more power and is more senior. Thirdly, it doesn't matter if the perpetrator didn't intend to make the person feel harassed. And equally, it doesn't matter if the harassment was only a one-off incident. Another point to bear in mind is that even if a worker has put up with harassing behavior for a very long time and they've not complained about it, this doesn't necessarily mean that it is wanted. And it might still be unwanted, which, as I flagged earlier, is one of the key characteristics that you need to pass to constitute sexual harassment. But the person may feel afraid of speaking up, particularly if the perpetrator is in a position of seniority. And, in that vein, a victim could also actively go along or even encourage certain behaviors, for example, flirting or sexual banter for quite a long time before reaching a tipping point where the behavior becomes unacceptable. Now, when considering the question of whether someone's actions might have created an intimidating, hostile, degrading, humiliating, or offensive environment, it's also worth remembering that this is a subjective test, which means it's for the person on the receiving end to decide how the perpetrator's actions made them feel. Having said this, for an action to actually constitute sexual harassment in law, it also has to pass an objective test. Now, this means if someone's being overly sensitive, then even if they subjectively felt intimidated, humiliated, degraded, this may not constitute sexual harassment in law. And a good example of an overreaction was seen in a case of Dos Santos v. Preview Services. And in this case, Ms. Dos Santos approached her supervisors with the word, "Can I ask you a favor?" And the supervisor replied, "Well, as long as it's not a sexual favor." And Ms. Dos Santos said that this was sexual harassment. But actually, the employment tribunal in this case decided that her reaction to a passing remark was just not reasonable. Had the supervisor said something like, "As long as it is a sexual favor," or accompanied his response with some sort of lurid hand gesture, then that might have amounted to harassment. This is a really tricky area, both legally and culturally, to determine, whether an act passes the objectivity test and amounts to sexual harassment. So in circumstances where you're not sure, it's definitely worth seeking legal advice. So who is protected and who is liable? Well, under the Equality Act 2010, your staff have the right not to be sexually harassed at work. And for purposes of sexual harassment protection, this includes not just employees, but workers, consultants, agency workers, and even job applicants or former members of staff. So who might be liable for an act of sexual harassment? Clearly, the perpetrator of the harassment can be liable and have a claim brought against them, but also you, as the employer, can be liable, because the Act provides that anything done by an employee in the course of employment is treated also as having been done by the employer. This is referred to as vicarious liability. And unless you can show that as the employer, you've taken all reasonable steps to prevent the harassment, the victim may be able to bring a claim directly against you as their employer. And this is in addition to, or even instead of, bringing a claim against the perpetrator. And in fact, this is actually most common because, employers tend to have and be the party with the deepest pockets. So there are some limits to vicarious liability, and I'm going to take you through those. The first is that vicarious liability extends only to actions of your staff or agents of the company. So it used to be the case that employers could be found liable for harassment carried out by third parties, such as a client of yours or contractors. But the law on this changed in 2013, and currently it would be very difficult for an employee to bring a claim against you for harassment perpetrated by a third party. The second limit to vicarious liability is that it only relates to actions committed in the course of employment. So what constitutes in the course of employment? Well, it extends beyond the four walls of the office. And in fact, it extends to all work-related situations and environments, including outside of working hours and at work-related events. So there's a few examples. If you're at a social event outside the office, obviously the dividing line becomes very blurred between conduct off premises at normal working hours, particularly if it's a social gathering. Some situations may be considered an extension of employment. So for example, a work Christmas party, a colleague's leaving party, or even informal drinks with colleagues at a pub immediately after work. Something like a chance meeting with a colleague outside of work is probably unlikely to be covered. We find that a large proportion of sexual harassment instances we deal with actually happen at these work-related events outside of the office. And also, we find that alcohol usually plays a pretty significant part in this. So as an employer, it's definitely worth carefully thinking about where and in what circumstances you allow or encourage drinking at work-related events. And also if there's anything you can do that might mitigate the risks that alcohol creates. So for example, some companies designate sober monitors. So when colleagues go out drinking, there's someone there to keep an eye on things. And a secondary advantage of this is actually that if you ever need to commence an investigation into something like sexual harassment, you could have at least one sober witness who's able to give an account of events during the evening. Another place sexual harassment might occur is actually virtually, and we have acted for individuals who've complained of harassment over, for example, Zoom. Similarly, an act of harassment that's done on social media, although it would be difficult to ascertain whether this was done in the course of employment, could potentially. Ultimately, incidents like this, which are borderline, are going to be a question of fact for the tribunal in each case, and they'll really have regard for all the circumstances when making that judgment. So before I pass back over to Emily, I want to finish this kind of basics section by looking at a bit more detail about the reasonable steps defence. So as I mentioned a moment ago, if you can show as the employer that you've taken all reasonable steps to prevent sexual harassment at work, you may be able to avoid liability for an act of sexual harassment that's perpetrated by a member of staff on another. Now, as the law currently stands, there's no minimum checklist of steps that you can rely on to demonstrate that you, as the employer, have taken all reasonable steps to protect your workers. What's going to be considered reasonable is going to vary from employer to employer. So if you're a smaller employer, you may have less resources and a smaller budget, and that might naturally lead to more informal types of practices and fewer written policies. If you're bigger, the expectation is going to be higher. Now, the EHRC, as it's commonly known, or the Equality and Human Rights Commission, had some really helpful guidance on things that you might want to consider when looking at the reasonable steps defence. And so we would recommend, if this is important for you, taking a look at this guidance after the webinar. But kind of to give you a flavour of what they suggest, the EHRC advised that all employers should have an anti-harassment policy, and that policy is communicated to workers and is effectively implemented, monitored and reviewed. And really what they say is, it is actually best practice for you to have a standalone sexual harassment policy, which sits outside of your general equal opportunities and harassment policies and covers the sort of things we're discussing today. Now, whether you have a standalone policy or not, you should ensure you have the right procedures in place to effectively deal with sexual harassment complaints. And that includes promptly and thoroughly investigating complaints and taking appropriate disciplinary action against harassers where that is appropriate. There are other reasonable steps you could consider, and most obviously is regular training for managers and supervisors in equal opportunities and harassment issues. But do remember that the length and depth of training is actually important. So brief superficial training, it's going to be unlikely to have a substantial effect in preventing harassment or have long-lasting consequences. And any training you do will also need to be refreshed from time to time. It's not enough just to do one session and go, okay, we're forgetting about it. So over the last few slides, I've outlined kind of basic legal framework underpinning sexual harassment. It's also worth noting, though, that the law around sexual harassment is set to potentially change, and it may become a lot more onerous for you as employers. So I want to touch on this very briefly. The government are currently supporting the Workers' Protection Bill, which is actually a private member's bill, which is trying to amend the Equality Act. And as currently drafted, the bill will lead to really two major changes that you should be aware of. The first is it's looking to try and introduce a positive duty on employers to take all reasonable steps to prevent sexual harassment to their employees. And this is different and a higher burden than the current position where you can actually choose to take reasonable steps in an attempt to limit your liability. But there isn't actually a kind of positive obligation at the moment for you to take those steps. The second thing is the bill is looking to introduce vicarious liability for third-party harassment. So that's harassment, for example, by your clients. And again, this is going to create much greater liability for you as an employer. So it's a very important law change to consider should it come into force. So the bill's completed its passage through the House of Commons, and it's coming to the end of its passage through the House of Lords. And the intention is that the bill is going to pass into law 1 year after it's passed by Parliament. So you have a bit of time before the new rules will apply, or even really until we know exactly what the new rules are going to be. Having said all of this, there have actually been recent murmurings that the bill might be shelved or dropped altogether. And that's because of concerns that actually this law is going to be really onerous for employers. So it's definitely one to watch. Right, I'm going to hand back to Emily now.
Thank you, Rebecca. So that's the law, but what can and should you do if someone makes a complaint of sexual harassment at work, which, as Rebecca has highlighted, can include a range of complaints, and it will require individual consideration depending on the nature of the complaint made. An automatic reaction may be, right, let's go straight to a grievance, let's go straight to a disciplinary process. But I think before doing so, you need to take a step back and give some consideration to the following before launching into that formal process. So firstly, consider who has made the complaint and how was the complaint made? Was it a passing comment in a conversation, embedded within an email, or a formal written grievance? You then have to consider the nature of the complaint. And whilst I'm hesitant to divide them into minor and more serious complaints, because that is quite subjective, or at least can be for the person making the complaint. From a legal perspective, there is certainly room for that terminology, and it is going to be a factor in deciding how you move forward. If you have one, look at what your sexual harassment policy says, use it and refer to it. It will give both you and the complainant guidance. And also consider at that point whether you need external support, whether that be legal, counselling, or even criminal. And I will come on to discuss that a little bit later on. Secondly, you will then need to think about what the complainant wishes to do and how they wish to take the matter forward. You need to be guided by them initially. And for this reason, before any decisive action is taken, discuss the complaint with them in order to understand whether they want to take the matter forward informally or formally. And I think for less serious complaints, an informal route may well be appropriate. For example, workplace mediation, which I often think is an unexplored but really useful tool for the right cases. So that's the initial response. You then have to think a little bit about how you have that conversation. And whilst the Me Too movement has gone some way towards changing attitudes towards those that have made complaints of sexual harassment, we're still seeing typical responses such as, is is the complaint true, but the perpetrator seems like such a lovely family man, or, you know, the victim is always flirting with colleagues, you know, all of that sort of narrative around when a complaint is made. I think particularly for more serious complaints, you know, victims will already have an internalized victim blaming dialogue and will likely feel ashamed, embarrassed, and blame themselves. And it's for this reason, when discussing an allegation of sexual harassment, and particularly a serious one, you should try and do the following things as set out on the slide. So I do know that you can, if necessary, receive specific training on this. But at a high level, the do's. Do listen, show that you're really listening and don't interrupt. Try and remember it's not their fault. Many people will already be struggling with those feelings of shame, guilt, and self-blame. Recognize how tough it might be for them to tell you, and let them stay in control by exploring their options. Be patient and respectful of their boundaries. Many victims find it difficult to trust people because of their experiences. So it's important that you don't betray that trust going forwards. In terms of the don'ts, don't ask them why they didn't say anything sooner. There are a whole host of reasons why victims may not tell anyone straight away, or even, you know, shortly after. Just because an allegation is historic, it does not mean that you should not take the complaint forward. Don't judge them for anything that they did before the sexual harassment, you know, what they were wearing, whether they were flirting, previous relationships. And don't ask them why they didn't run away or fight back. A common response to people who've experienced sexual assault or abuse is that they freeze and they cannot move or even speak. And that's an automatic response to fear that can happen to people. And they're not in any way to blame for that. And I guess lastly, don't judge them on how they have responded to their sexual harassment. There is no right way to react to that experience, and everyone responds differently. Having had that initial discussion, there may then be some further tricky or complex issues which arise. And I'm just going to touch on a few of these now. So the first is, well, what if the complainant doesn't want to take any action? Should you respect their wishes or continue with the investigation regardless? This is such a difficult position for any employer to be in, and it will come down to a judgment call. Where possible, you should respect the wishes of the complainant, because not doing so could compound the harm caused. However, you will also need to conduct your own balancing exercises that amounts really to an internal safeguarding exercise. If the complaint is of a serious nature or involves a serial perpetrator, which could impact the safety of other workers, then it is highly likely that you will have to take further action. And that will be particularly relevant if there's an element of criminality, which, as I said, we'll discuss a little bit later on. In addition to that, keep a record of the complaint and the fact that they wanted to keep it confidential, and provide the complainant with any guidance or support on how the situation could be resolved. Keep the situation under review. If it persists, explore whether further action should be taken at a later date. Where it is decided that formal action does need to take place, despite the individual's wishes, make sure that you communicate this with the complainant and your reasons for doing so. It's also important to consider any further safeguards which may need to be put in place to prevent further harassment or victimization from happening, which Rebecca will discuss. I think in these situations, gossip, retaliation is almost inevitable, and that's why providing that support and counselling going forwards is really important. Linked to that is, well, what if the complainant wants to remain anonymous? the same issues I've just mentioned will come into play here. And whilst you may be able to progress an investigation on an anonymous basis, I just don't think as an employer you can make that a resounding promise. Depending on the size of your organization, the teams, the people involved, it could become quickly apparent in any investigation who the individuals are. And so I think the best that you can do is commit to do your best and reiterate the protective measures that you will put in place to avoid any victimization and retaliation. And what if the complainant is not the victim? So typically the complaint comes from the victim themselves, but what we're seeing more of is complaints by third parties who have witnessed the sexual harassment. And given a worker can still claim harassment even where they're not the victim, you still have to follow a process. But again, I would go back and discuss that with the complainants themselves and ask whether they in fact want to take the matter forward. If not, does your duty to investigate override the victim's duty not to take any action? And again, we go back to that internal safeguarding balancing exercise that you will need to do, which will depend on the nature of the allegation. After that process, if you do decide that formal action is required, you will need to ensure that there has been a fair process. And on the slides now, you can see that I've outlined. I'm sure that you're very familiar with a formal grievance and disciplinary process. I do just want to pick up on a couple of points here. So the first is, does anyone need to be suspended, and in particular, the alleged perpetrator? First port of call is always going to be, what does the employment contract say about suspension? You need to ensure that your employment contracts give you that contractual right. And also whether you could withhold bonus payments, for example, until the outcome. At a high level, suspension should be a last resort and not a knee-jerk reaction. And you have to demonstrate that you considered other alternatives to suspension. ACAS has excellent guidance on this, and I'm not going to go into it now, but there's lots of case law around the act of suspension. So it really is something that as employers you should be considered properly. So, and then we'll have to carry out an investigation, hold the relevant meetings and communicate the outcomes as well, and appeals, consider if companions need to attend as well. So what I want to do is actually focus in on the investigation stage of these formal processes. The reason being is that the basis for ensuring a fair outcome starts with ensuring that a fair investigation has been conducted. If a poor investigation has been conducted, then this will often lead to poor outcomes, further complaints, exposure to legal liabilities, and that, of course, is time-consuming and costly to the business, both financially and emotionally. And generally, it is difficult for businesses to row back from a poorly conducted investigation. So here are some points to consider in how the investigation process should be adapted when dealing with complaints of sexual harassment. The first is, don't set a time limit within which complaints must be made. As I mentioned just a moment ago, just because an allegation is historic, whilst it may be out of time from a claim point of view, it should still be investigated in line with normal procedures. And this is particularly the case where if you have a serial sexual predator, you must ensure that your workforce is protected from further misconduct. I think then the question is who conducts the investigation, and I would personally advise to instruct an independent investigator from the outset and avoid keeping it in-house. Yes, it will be more costly, but it will mean that you reduce any future criticism of a biased outcome. I think particularly where the nature of the complaint involves a very senior person within the business, can the business fairly investigate the complaint? Or would it be preferable to engage an independent investigator from the outset? Another thought is whether if a woman has made an allegation of sexual harassment, should the investigator also be a woman? Maybe ask the complainant if they have a preference. Does the investigator have experience of dealing with complaints of sexual harassment? I mentioned the do's and don'ts earlier, and depending again on the nature of the complaint, you will need someone who can handle the impact of trauma and put in place those do's and don'ts. Ensure the investigation is conducted in a timely manner. An elongated process can cause the complainant to feel that they are unsupported or not believed. If the investigation does take longer, which is often can be the case, provide regular updates. And then a key factor underpinning the investigation as a whole is confidentiality. I think you need to communicate that a breach of confidentiality could be a separate disciplinary offence or lead to further complaints. And again, you need to demonstrate to your workforce that you are cracking down on any victimizing behaviours, so the office gossip, the cold shouldering, both to reduce your own legal liabilities, but to protect the complainants and the alleged perpetrator's well-being. The same principles will also apply if you are going through a disciplinary process. And in fact, you may start with an initial investigation for the grievance and then require further investigation for any disciplinary process. So we've thought about how to manage your initial response and what to do when a formal resolution is needed and how the associated investigation should be managed. But on top of this, there may be an additional layer of complexity, again, depending on the nature of the complaint and also depending on the sector in which your business operates. So turning to this, what if the allegation is potentially amounts to criminality? I don't have all the answers here, but I just want to highlight the thoughts which you should be considering if there is a criminal aspect to the complaint. Firstly, be aware that the criminal position keeps evolving. For example, there have been recent new criminal offences such as upskirting, downblousing, and revenge porn. Also, it's the case that any sexual harassment which takes place abroad, so on the annual ski trip, could now have criminal implications in the UK. One of the questions may be, should the matter be reported to the police? And should you continue with your internal investigation? To note, there is no specific obligation or legal obligation for an employer to report a matter to the police. But if you do, you need to be mindful of breaches of GDPR. Again, this will very much depend on the seriousness of the allegations. And I've said this quite a lot already, but you've got to revert back to that internal balancing and safeguarding exercise. You may want to include a point in your sexual harassment policy that employees have a right to report a complaint to the police, and that where possible, to let you, the employer, know that they have done so. And the reason being is that your internal investigation could impact a criminal investigation, and you just wouldn't want to mess up that police investigation. If the employee tells you that they have reported to the police, do consider whether you should contact the police as well and let them know what you're doing and ask questions about their process, basically to ensure that any parallel processes that are running are done so smoothly and don't impact the other. Be mindful that an internal process, whilst it will require the alleged perpetrator to cooperate, that is not the case with a criminal investigation, where the response can simply be no comment. With that in mind, a suspect will not want to cooperate with an internal process if it will have a detrimental impact on any criminal investigation. Consider what you can do to allow that constructive conversation to take place and allow the suspect to effectively participate. For example, can you provide written questions and allow for written answers? There's also a question about whether you should conduct an internal interview under caution. I just would like to say, please seek legal advice before doing so, because once you start doing that, you could become an investigator. And then there are rules called PACE about how to conduct the meeting, and record keeping, etc., come into play. And I'm sure that you wouldn't want to adversely affect a criminal investigation, but there are a range of views on the topic. Just very quickly, and without alienating some of our audience members today, another consideration is whether you have to report to a regulator. So we act for law firms, and obviously they're regulated by the SRA, and also if you're in financial services, and the FCA. Your own industries may also have their own regulators and require you to report sexual misconduct. It's fair to say that both the SRA and the FCA have been impacted by the Me Too movement, and they are really focusing their resources to raising awareness with the intention to reduce sexual misconduct within these sectors. I think the main questions, if there is a duty to report to a regulator, is do you have to report, and when? At a high level, you need to report when the complaint is sufficiently serious and linked to the individual's work. Broadly, unless the conduct is serious to the extent that it offends public trust and confidence, actions which take place in private settings are unlikely to merit regulatory action. The SRA, they expect you to report when sexual misconduct has been found, and with the FCA, you must report where you've taken formal disciplinary action for harassment. So that may be either during or at the end of a formal disciplinary process. One point which I do want to flag, and it may well be worth checking the same within your own industries, is that the SRA has a memorandum of understanding with the police. And what that means is that the SRA and the police can share information with each other about their respective investigations or allegations. So worth bearing in mind. I am now going to hand you over to Rebecca.
Thank you, Emily. So to finish, we just wanted to take you through the potential claims that you might face in this area. And there are a number of claims which you as an employer could be exposed to following a complaint of sexual harassment. Claims can be brought by the person who's the victim of sexual harassment, the person who reported the sexual harassment, or even the person who's accused of sexual harassment. So I'm going to cover what we kind of see as the most common claims now. The first and most obvious is sexual harassment itself. And I've already covered this in some detail, but as explained earlier, you as the employer may be vicariously liable for an act of sexual harassment, which is perpetrated by one of your staff members on another. And this means the person who's been sexually harassed can bring the claim against you directly, instead of, or as well as bringing it against the perpetrator. Another common claim that we see in this area, which flows from incidents of sexual harassment, is a claim for whistleblowing. And as many of you may know, whistleblowing is where an employee discloses information which that person believes is either a criminal offence or a breach of a legal obligation or a miscarriage of justice or a danger to health and safety. And if a person reports an instance of sexual harassment, whether they're the victim or not, they might garner this whistleblowing protection. And that's the case even if it's found that no sexual harassment occurred. So as long as the person making the report believes that, for example, a criminal offence has taken place, they could still be a whistleblower under whistleblowing law. Now, once a person is a whistleblower, it means that you as the employer cannot treat them detrimentally because they've blown the whistle. So, for example, you shouldn't make them feel excluded, dock their pay, future bonuses, demote them, dismiss them just because they made the report. And a good example of this was seen in Tokyo Marine Kiln Group, which is a case a few years ago. And here, there were a couple of executives who resigned after sexual harassment allegations were made against them. And the in-house lawyer, who wasn't the victim of harassment, blew the whistle on the culture of harassment in the business following this, and then brought whistleblowing claims against TMK and its CEO and its head of HR. Now, similar to a whistleblowing claim, but under a different piece of legislation, is a claim for victimization. And this is another common claim that we see linked to sexual harassment. We've touched on this areas during this webinar. So victimization is where essentially, because someone's made a report in connection with the Equality Act, and that covers making a report about sexual harassment, a person is then treated detrimentally or victimized because of the fact they've made that report. You can probably see that this sounds very similar to a whistleblowing claim, but there are a few distinct differences. And first of all, it's under a separate statute, so it's under the Equality Act rather than the Employee Rights Act, which means it's its own standalone claim. But secondly, broadly speaking, whistleblowing claims are going to be far harder for a claimant to succeed with, as there are a lot more hurdles that they're going to need to get over in order to link their whistleblowing act to a subsequent detrimental treatment that they're arguing about. Whereas for an employee to succeed with a victimization claim, it's going to be enough if they're just able to show that one of the reasons for their bad treatment, such as being dismissed, was because of them reporting the incident of sexual harassment. Now, claimants can run both whistleblowing and victimization claims at the same time, which is why I want you to be alive to both. There are also a couple of other claims. I'm not going to go into too much detail as they're less common, but I do want to just put them on your radar. And one's a claim for personal injury, and that's where a person who's been sexually harassed, when it's particularly severe, they may in fact have a personal injury claim. The other is for constructive dismissal, and that's where an employee effectively dismisses themselves because of the poor treatment that they've received. So it's just worth bearing those two in mind. Okay, so we've now covered the key claims you might be exposed to from the victim of sexual harassment or the person who reports it. But what about the person accused of sexual harassment? It's really important to remember that a person that's accused may not be guilty of the thing that they are accused of doing, or there might be really relevant mitigating factors which you need to take into account before taking action against them. For example, if they have a disability that may have caused them to behave that way, you need to take that into account. So in these circumstances, as a business, you could be liable for claims from someone accused of sexual harassment. And really, there are two main claims that we see in this area. The first is a claim for unfair dismissal. And this usually arises where you dismiss someone after allegations of sexual harassment are raised against them, but that person insists that they are innocent. Now, as you all probably know, a person needs 2 years of employment before they can bring an unfair dismissal claim. However, once they have that 2 years of employment, you as their employer will need to be able to demonstrate that you have a fair reason to dismiss them, and also that you followed a fair process before doing so. So sexual harassment would be a fair reason if you reasonably believed that an act of sexual harassment had taken place. However, you also need to demonstrate you followed the fair process. So you should ideally do a thorough investigation and a complete disciplinary process before you reach any decision. And Emily has obviously discussed this with you earlier. Now, the other sort of claim that you should have on your radar, as it's one we are increasingly coming across from those who are accused of sexual harassment, is a claim for discrimination. Now, you might have heard this referred to as the pale male stale claims. And in essence, this is where a person argues that they're being treated less favourably than a colleague might have because they are white, or because they are old, or because they are a man. And claims of this sort usually arise where a person is absolutely adamant they've not committed an act of sexual harassment, and they feel that their employer is disregarding their version of events or running an unfair process simply because the employer assumes, purely on the basis of the person's sex or age or race, that the accusations must be true. So in order to avoid this sort of claim, it's helpful if you can avoid making predetermined judgments on the guilt of the parties. And the best approach is for you to carry out a thorough investigation and disciplinary hearing and consider all the evidence and representations made from both sides before making any decisions or taking any actions which you later won't be able to reverse. So what are the time limits for bringing these claims that I've just run through, and what compensation could you receive, or could someone else receive if they are successful? So for sexual harassment, whistleblowing, victimization, unfair dismissal, and discrimination in the employment tribunal, the time limit is set at 3 months. So what this means is a claimant needs to commence proceedings or take the first step in commencing proceedings, which is to contact ACAS, within 3 months, less 1 day of the date of the act complained of. So, for example, if you have an act of sexual harassment that, say, takes place on the 2nd of May, 2023, the person claiming they are the victim of harassment officially has until the 1st of August, 2023 to contact ACAS to start making their claim. Now, where the complaint is about a series of acts, for example, multiple instances of sexual harassment or multiple acts of victimization, then a person may be able to bring their claim within 3 months, less 1 day of the last in those series of acts. Now, you should also be alive to the fact that individuals with sexual harassment claims, particularly where the allegations are of serious sexual assault or rape, might feel unable to bring their claim within the time frame that applies. And the employment tribunal do have discretion to accept claims that are out of time and are late, if it considers that there are just and equitable grounds for doing so. There are also possibly plans to extend the time limit to bring sexual harassment claims to 6 months from the current 3, but it's not clear if that change is going to come into force, so not one to worry about just yet. So, very final point, what about compensation? And I do want to draw your attention to the financial implications of a claim which might be brought against you as a business, and that is really putting aside any reputational damage that might be caused, which in practice is often going to be a business's bigger concern. So an unfair dismissal claim is capped at around about £100,000. However, for all the other claims we've discussed, sexual harassment, whistleblowing, victimization, discrimination, all of these are uncapped. And this means the amount of compensation a claimant could receive if successful is potentially unlimited. However, generally speaking, compensation will be based on a claimant's actual financial loss, such as how long were they out of work for after they left your employment. There are more punitive awards in an employment tribunal that they can make, such as injury to feelings and aggravated damages, but these sums are likely to be minimal compared to the overall award unless what has taken place is kind of very severe. So that brings us to the end of today's webinar. We hope you found it useful. On the slide, you will see our contact details, and please do feel free to get in touch with us in connection with anything that we discussed today.